Hello and welcome to the Ohio Estate Planning Secret Seminar. I'm attorney Edward Littlejohn and I'll be our host for tonight. And tonight we're going to go over some Ohio estate planning secrets, what some lawyers don't want you to know. And in this, I'm going to be covering some tips and tricks that I've learned over the years to help our clients protect their assets and avoid costly mistakes. Just as a couple of housekeeping issues, if you have any questions, feel free to put them in the chat, and I'll be glad to answer those questions throughout the presentation tonight. So again, my name is attorney Edward Littlejohn. I'm the founding attorney and CEO here at Littlejohn Law. And I started Littlejohn Law on the idea that people need access to information, right? If people have information, they'll make good decisions. And so we always have had seminars, whether in person or virtual seminars, as well as we've created several books and guides for people to have access to information so that they can make well-informed decisions. So jumping right into kind of some estate planning tips is I'm going to go through some misconceptions and I will separate those misconceptions in terms of fact and fiction. And again, if you guys have any questions, feel free to ask as we go on. So the first misconception that I want to talk about is this idea that everything has to go to probate court when your loved one passes away. Now, the reality is everything does not have to go to or through the probate court, but rather things have to go through the probate court based on how they're titled. So it's very important to understand that there's what we call probate assets and non-probate assets. Now, the simplest way that I've learned to distinguish between probate assets and non-probate assets are if the asset requires the deceased signature to transfer. So if I have a car and it's in my name and I want to transfer it to my children and I pass away, they're going to need my signature to transfer. And because they need my signature to transfer the car, it will be considered a probate asset. Now, some people have cars in what's called TOD, which is transfer on death. So the title would be in my name, but TOD to someone else. If your vehicle is TOD, then that will be considered a non-probate asset because you would not need my signature to transfer it, but rather you would just go down to the BMV and provide them with a copy of my death certificate, and then they would automatically transfer the asset to your loved one. The most common non-probate assets that we see are life insurance policies and some retirement accounts like 401ks or IRAs. So again, everything does not have to go through the probate court process. So one of the first things that my team and I do is we sit down with you and we look at your assets. So if your house is in your name only, then it would go through probate. But if it's in survivorship or it has a transfer on death designation, then it's going to be considered a non-probate asset. Again, not all assets have to go through probate. We have to look to see how they're titled, and that will determine whether they're going through the probate process or not. In fact, you can take an asset that would go into probate and have it titled in a different way to avoid the probate process altogether. The second misconception is thinking that you have enough time for planning, right? Far too often, my team and I have worked with families who contacted us and they said, hey, our loved one has had a stroke and we need to get appointed as their legal guardian. Now, the guardianship process is a process where you petition the probate court to appoint you either a guardian over the person or their estate. And what we're talking about is you can be a guardian to make healthcare decisions for them or to really make financial decisions for your loved one. As a part of the guardianship process, the probate court is going to want to have some sort of medical testimony, whether it's a doctor or a psychiatrist, to say that your loved one is incompetent and not capable of making their own decisions. Typically, the way it works is you petition the probate court for the guardianship, and then Unless it's an emergency guardianship, the probate court will set the hearing out for approximately 2 months. So that 2 month time period is a significant time period where we've seen multiple people end up passing away before we got to the hearing for the probate court. And in those instances, the family members thought they had more time. And the reality is their loved one's health declined drastically. And as a result of that decline, they ended up passing away and we were not able to get the guardianship. So, one of the things that my team and I highly recommend is a healthcare and financial power of attorney. Now, the healthcare power of attorney is a designation by you to someone else to make healthcare decisions for you in the event that you can't make those decisions for yourself. And the financial power of attorney allows someone to make financial decisions for you in the event that you can't make those decisions for yourself. We like to call them trusted family advisors, right? These are the people who are going to make healthcare and financial decisions for you in the event that you can't make those decisions for yourself. Now, here's the thing. If you have a power of attorney, the probate court will not give you a guardianship. And we highly recommend the power of attorney because it's something that you can do while you're still competent, right? You can decide who you want to be your trusted family advisor. Several months ago, my team and I were working on a case where a mom needed a guardian and her children wanted to be her guardian, but her husband also wanted to be her guardian. And it was a very weird family dynamic where there was allegations of abuse between the husband and the wife, and the children didn't want their father to be her guardian, but they wanted to be her guardian. And it ended up turning into a contested legal battle. And so ultimately, in that particular case, she ended up passing away before either party was able to achieve the guardianship. But had she had a healthcare or financial power of attorney, the person she wanted to be her guardian would have been able to make healthcare and financial decisions for her. And it could have avoided a costly headache and a mistake for their family. Okay, any questions out there? Any questions out there? Nope. All right, not seeing any. Again, if you have any questions, feel free to put them in the chat. Put your questions in the chat. Okay. Great. So again, we've covered two misconceptions. The first misconception is thinking that everything has to go through probate court. The second misconception is thinking that there's enough time for planning. Again, we highly recommend that you get a power of attorney. Designate somebody to make healthcare and financial decisions for you. The third misconception that we see far too often is thinking that probate court isn't going to cost that much. So, under Ohio law, there is a statute that lays out what we call the fiduciary fee. And the way the fiduciary fee works is it's an administrative fee that gets paid to the person who's either the administrator of the estate or the executor and to the attorney. So the attorney's fees and the fiduciary fees kind of model the same legal statute. Under Ohio law, generally speaking, the fiduciary fee is 4% of the first 100,000, and then it's 3% of anything over 100,000 but less than 400,000, and then 2% of everything over 400,000. Okay? So again, 4%, 3%, 2%. Now, each probate court has the ability to modify this fee. Some probate courts have modified it where the first 100,000 is 4.5% or 5%, and then there's a different tier. So each county has a slightly different fee structure, but it's based on this particular statute. In addition, if there's assets that are not sold, being real property not sold, the fiduciary is entitled to 1% of any real property not sold, and then 1% of all property not subject to administration. Now, property not subject to administration is property that will be considered non-probate assets. So your fiduciary is entitled to a fee of the non-probate assets of 1% of all the assets not subject to administration. So commonly we see families have an estate valued at approximately, let's just say $250,000. That would include your house, your car, your bank account, um, maybe some retirement accounts. But let's say there's $250,000 and all of it is probate assets. So the way the probate court would have this broken down is 4,000 for the first 100,000, and then from everything from 100 to 400,000, so that would be another 150,000 at 3%. That's a $8,500 fee. Okay. So the fiduciary fee off of a $250,000 estate will be $8,500. In addition to the fiduciary fee being approximately $8,500, you would have an attorney's fee that would model that. Then additionally, there's the probate fee, which ranges anywhere from $250 to $350, the filing fee. Then if you have to post a bond, that ranges anywhere from $500 to another $1,000. And then there could be recording fees and titling fees for deeds or vehicles. So if we just do a low number on all of that, we have $8,500 for a fiduciary fee, $8,500 for an attorney fee. Let's call it $400 for probate, filing fee, recording fee, title fees, and then $1,000 for the bond. We're looking at $18,400 as a probate fee on an estate that's worth $250,000. So if your estate is worth less than that, obviously the fee would be lower. And if it was worth more than that, the fee would be higher. But this misconception that probate court isn't going to cost that much, it is a big one out there that we see. Probate court will cost your family a lot. In addition to kind of the monetary cost, there's a time cost. In general, the way the probate court process works is number one, someone has to petition the probate court to be appointed as the administrator of an estate or an executor of an estate. Now, the distinction between the administrator and the executor comes out if there's a will or there's no will. So if there's a will, you would be considered the executor of the estate. If there's no will, then you would be the administrator of the estate. Now, once you submit everything to the probate court, they have 90 days to approve the administrator to be appointed as that administrator. And same for the will. We've had cases where we've submitted a will to the probate court. The probate court received objections from other heirs or beneficiaries that said that they didn't want that particular executor to be appointed as the executor, or even the administrator to be appointed as the administrator. And then that turns into a kind of a contested battle for the parties to prove their fitness to be the administrator of an estate. Now, once that happens, the probate court will have a hearing and decide whether the person is fit to be the administrator of the estate. Now, the probate court's going to want to know that this person is going to be trustworthy. They're going to follow the law. They're going to provide notice to the next of kin and to the beneficiaries, and then they're going to disperse the assets pursuant to the court order as instructed by the judge. So once that is established, the probate court will appoint someone to be the administrator or the executor. And the way they do that is what's called a letter of authority. Now, I call a letter of authority a magic key because this letter of authority would allow you, as an executor or administrator, to go into the bank and collect all of your loved one's assets, right? So you got this magic key, you can collect all the assets, and then you submit everything to the probate court as an inventory. And then people have the opportunity to say, hey, there are assets missing. I remember mom or dad had, a car or a different bank account or some other money here. And then the probate court sets that down for a hearing. So now we're at 90 days for the letter of authority. And then 90 days later, we're having a hearing on the inventory. Once that happens, there's another 90-day period where the probate court allows us to do what's called an accounting, where we list all the assets and kind of determine a plan for how we're going to distribute the assets. Now, this responsibility is the responsibility of the fiduciary and the attorney who's handling the estate. And so what we see far too often is, again, people thinking that probate isn't going to cost that much when we're looking at a period of 9 months here and on a fast track. 9 months where your assets are tied up in the probate court, 9 months where we're accumulating a bunch of fees on an estate, 9 months where that money or the vehicles or the home could be used for your loved ones or could even have been sold, but it's tied up throughout the probate process. And so again, probate, it costs a lot, in my opinion, because of the time delay as well as the potential monetary cost. Okay. Looks like we have our first question out here. Let's see. Okay, perfect. So the question is, when all assets are placed in a trust, including probate assets, what is the process for transferring the title of a car? Great question. Great question. So if we take an asset that was a probate asset and we put it into the trust, what we're doing is we're changing the ownership of that asset. So think of it like this. A trust is a separate entity from yourself, almost like a separate person under the law. Okay. So if there's a car that we put in the trust, what we've done is we've taken the title of the car from my name and put it in the name of my trust, the ABC Trust. So now that my vehicle is in the name of the ABC Trust, there's going to be someone called the trustee who's in control of those trust assets. Now, the trustee has the ability to distribute the assets. The trustee has the ability to sell the assets. The trustee has control over the assets. So, unlike the first example where a car is in my name, we have to go through probate, we have to petition the probate court for the letter of authority. Then we have to, if we were to transfer a vehicle through probate, the probate court would issue the letter of authority. We would have to get the vehicle appraised. Typically, we use the Kelley Blue Book values of the vehicle. The probate court would have to accept that value on the inventory. And then if we wanted to sell the car, the probate court would have to approve that sale of the car. Now, let's say we didn't want to sell the car, then the probate court would give new titles in the names of the heirs or the beneficiaries. So for me, I have 2 children. The probate court would issue a new title in both of my children's names. Okay. And again, that would happen after that 9-month period of time. Whereas if I had that same vehicle in a trust and my trustee has absolute control, if I pass away, my trustee could sell that car today. My trustee could give the car to the beneficiaries today. It would avoid the probate process. It would avoid the delay. The process is streamlined and easy because we're giving the control to the trustee. And in most of the cases that we see, the trustee would be the same person that the person a deceased would have named as a executor. So they've already identified someone to be a trusted family advisor, and they would appoint them to be the trustee. They would have absolute control to transfer the property today, as opposed to 9 months later after they got the probate court's permission. Looks like next question. The wife is the beneficiary of the probate asset. Is the trust officer still involved? If the wife is the beneficiary of the probate asset, is the trust officer still involved? Well, it just depends on the asset. So when again, I guess I want to make sure that I say this clear. When we talk about probate assets, what we're talking about are assets in one person's name only. Let's just call it that to keep it simple. So if I have a house in my name only and I die, that house is a probate asset. If I put my home in a trust and I die, that home is a non-probate asset. Okay. So it all depends how it's titled. If it's in my name individually, it will be considered a probate asset. If it's in my name and someone else's name, that could be considered a non-probate asset in survivorship. If it's in my trust, that will be considered a non-probate asset. So if the wife is the beneficiary of an asset, right? If it's an asset that's titled in the name of the trust, then that will be considered a non-probate asset. If the asset is not titled in the name of the trust, it would be considered a probate asset. Now, there are some scenarios where the asset could be titled into the trust, and the designation could say, when I pass away, I want this asset to go to my wife. So some of our clients, when we create their trust, they have very specific assets that they want to go to specific people. Just the other day, I was working on a trust with one of our clients, and he had a specific home that he wanted to go to his daughter, but all of his other assets he wanted to be sold and distributed evenly between his son and daughter. But one home, and it was the family home, he wanted to make sure that that house went to his daughter. So inside his trust, he had, say, two homes, car, bank account, um, two homes, car, bank account. Home one, he wanted to go to his daughter. Home two, car, bank account, one of those assets to be sold and distributed amongst his son and daughter. So I hope that answers your question, that if there is a beneficiary with an asset that's titled in the trust, that beneficiary receives the asset. The trustee may be involved only to sign the new title or only to actually carry out the distribution. Okay. But again, if you want your asset to go to your wife, you could make it transfer on death, or you could own a piece of property in survivorship. We see a lot of families owning property in survivorship, which is a great tool to protect your assets. Excuse me. Make sure I go over that next. Now, before I move into our last misconception, I do want to talk about survivorship and trust. So, a survivorship is a designation where multiple people own a property in survivorship, which means we both own the property, but whoever outlives the other person gets the entire property. Now, a trust can be set up very similar, but typically the trust owns the property and there may be multiple beneficiaries. So some of our clients will put a family home in a trust, and by putting a family home in a trust, their goal is to make sure that that home stays within their family for generations to come. A couple months ago, I was working with a client who's owned a farm since the 1800s. His family, it's over 600 acres of land that's been in their family since the 1800s. And so it's very important for it to stay in their family. In fact, they had a trust to make sure that it transferred to their children and to their grandchildren, but it wasn't in survivorship. Again, survivorship is different than a trust. Now, the last misconception that we see is people thinking that Medicare will take care of everything. Now, that's a big misconception that we see. First off, I want to make sure that we have the distinction between Medicare and Medicaid. Medicare is a program for people 65 years and older. Medicaid is a state and federally funded program. In fact, the program applies to the elderly, to the disabled, and to low income. Now, what people don't realize is that Medicare only pays the first 100 days in a skilled nursing home facility. Okay. After the 100 days, so 101, you are fully responsible for the care. So what happens is people say, hey, well, how am I going to pay for this care? And they attempt to get on Medicaid. So Medicaid, again, is a state federal funded program that will take care of people when they're in that skilled nursing home facility beyond the 101st day. And typically what we see the distinction is if you're in the nursing home for some sort of acute issue, Medicare will take care of it, but again, up to 100 days. And if it turns into something more chronic, then the nursing home makes you fully responsible. And again, most of our clients say, hey, I'm going to see if I can get qualified for Medicaid so that I can get the care that I need. Now, one of the things that we do with those clients is we create what's called a Medicaid Asset Protection Trust. Now, the Medicaid Asset Protection Trust is a tool that we use so that two things happen. Number one, the person that needs to qualify for Medicaid can qualify. And number two, they can keep their assets. A lot of people have heard about what's called the spin down. So, oh, I want to go into the nursing home. I want to qualify for Medicaid, but I have too many assets. Under the law right now, a married couple can have $2,000 of countable assets. Now, what's countable assets? The countable assets are the liquid assets. So that is your bank account can only have $2,000 in it. If you have a whole life insurance because it has a cash value, it can only be $2,000. Now, there are certain tricks that we've used in strategies that will allow the non-institutionalized spouse, who we call the community spouse, to shelter some of those assets. But generally speaking, to qualify for Medicaid, you're looking at certain income limits and asset limits. And the Department of Medicaid has an estate recovery team. And here in Ohio, they've been pretty aggressive over the last I would say at least the last year, been pretty aggressive. And what do I mean by that? Last year, my team and I were working with a lady on her estate. Her mom had passed away, and there was a life insurance policy that was a $50,000 policy, but it only had a $800 cash value. And the reason why we were going through probate court was because a mom had taken a life insurance policy out on the daughter, but the mom was the beneficiary of the policy. And so, since the mom was the beneficiary of the policy, we needed to go to probate court to change the beneficiary of the policy, even though it was on the daughter's life. And when we did that, Medicaid said, whoa, we paid a bunch of bills on behalf of mom. In fact, we paid almost $300,000 of bills on behalf of mom, even though this is a $50,000 life insurance policy, the fact that it has an $800 cash value, we want that. And so ultimately, Medicaid wanted them to surrender the life insurance policy that was on the daughter that's still alive in the amount of $800 to satisfy this $300,000 claim. And so what we found is that early planning is best. Currently, there's a 5 year look back. And so what that means is if you need to go into the nursing home, 5 years ago, we should have started planning. Now, my dad always said the best day to plant a tree was 25 years ago. The next best day to plant a tree is today. And so if you're on the fence about what you should do, then you should schedule a complimentary needs assessment with my team. And by doing so, we will be able to help you identify your goals and figure out what the best next step is for you and your family. Now, in this complimentary needs assessment, my team and I will go over your goals. We'll go over your assets to see how they're titled so that we can help you avoid the probate process if that's your goal. We'll go over the 4 critical documents that you need, one being a trust. We've already covered the healthcare and financial power of attorneys. And then the last being what's called a pour over will. Now, a pour over will is kind of my catch all, and we use it as a catch all because if there's an asset that was in your name at the time of death, the pour over will give the probate court limited jurisdiction over the asset to transfer it to the trust and then distribute it pursuant to the terms of the trust. Now, please, I want to open it up to any questions that you guys may have. I'm going to put the link in the chat here, put the link in the chat and open this up to some questions. See if you guys have any questions. Any questions out there? Any questions out there? Feel free to unmute yourself and go ahead and ask your question if you have a question. Any questions out there? Going once. Going twice.
Ed, I
Yes.
do have a question regarding the pour over will or the pour over
Yes.
inside of a trust. I don't know that I'm saying that correctly.
Hmm.
Could you speak to a pour over will again? Because that's an individual taking all of their assets, correct?
Yes, ma'am.
And then putting all of those assets into the trust.
Yes.
Okay.
So the way the pour over will works is, again, let's start before we get into pour over will. Let's go back to the trust. I'll go back to the trust. If I have my house in my name, I die, that's considered a probate asset. So the first thing I'm going to want to do is put my house into the name of my trust. And let's call it the ABC trust. So now my trust owns my house. The house is in the name of the trust. If I die, that's considered a non-probate asset. But let's say I forgot to title my car in the name of the trust. Now I pass away. I have the pour over will. My family gets the pour over will. The pour over will says all of Edward's assets go into his trust. The pour over will is very similar to a regular will, where a regular will may say, give the assets to his children. The pour over will says, give the assets to his trust. And so any asset that was not titled in the name of the trust, the pour over will is going to go to probate court. The probate court's going to appoint somebody as the executor, and then they're going to take that asset and they're going to transfer the title to the name of the trust. And then the trustee is going to be able to distribute the assets pursuant to the terms of the trust. Now, the only reason we use the pour over will is because a lot of times what happens is my team and I, when we sit down and we do the planning, we will do all the initial funding. We'll put your home in the trust. We'll put your bank accounts in the trust. We'll put your car in the trust. But sometimes people get other vehicles, right? They might get another bank account they forgot about it. So when they die with some assets being non-probate assets, and then they die with some assets being probate assets because it wasn't properly titled. In fact, I had a client, this probably 10 years ago. We had set her up a trust and put all of her assets in the trust, and she passed away. So we were like, hey, everything's great. But what happened was she had a great niece, and her great niece actually left all of the assets that she had to her. So her trust did not cover the assets that she was going to inherit because she didn't know she was going to inherit those assets. So they weren't properly titled in the trust. But because her niece left her everything, we had to go through the probate court with our pour over will to say, hey, transfer everything to her trust, and then it'll be distributed pursuant to the terms of the trust. Hopefully that makes sense.
It does. However, there's just another little wrinkle, and it
Yeah.
goes back to the question that I asked earlier around the car and the trust.
Hmm.
Um, because my husband,
Hmm.
a pour over will took all of the assets and put into the trust,
Yes.
but he left me as beneficiary with with that asset and other personal assets. So, am I making sense?
Yeah. So the assets, were the assets probate assets or non-probate assets?
Well, it would have been a probate asset. And I'll go back to the car because that's the one thing that we can't talk about is the car.
Okay.
The car was in his name.
Hmm.
And then he um,
So he
used
had the car in his name, but he also had a pour over will that said any assets that are in my name at the time of death go to
personal
my
belonging
trust,
goes to my wife.
goes to my wife. Okay.
Yes, yes.
Okay.
So,
Did he have a trust?
yes,
Okay. So in his trust, he said everything goes to my wife, right?
yes.
But he also had a pour over will that says give everything to my trust.
No, the pour over will said, give all of my personal assets to my wife.
Okay.
I know it's confusing, isn't
Right.
it?
So he had a trust that
But
left some assets to you, but then he had a
yes,
pour over will that said give all the personal assets to my wife.
yes,
Okay. And so your question is about a vehicle.
yes.
Great. And this is why my team and I, this is why we do what we do, because there is an exception, because you're bringing out the exceptions, which is really great. So under Ohio law, a surviving spouse has the right to elect to take against the will. So what that means is the will could say, I give everything to one person, not my wife. Okay, so I give everything to somebody other than my wife. But because Ohio law allows the wife a right to elect to take against the will, she or he has that right to do something different than the will actually says. Now, the most common thing that we see is vehicles. Under Ohio law, a surviving spouse has the right to take an unlimited amount of vehicles up to the aggregate value of $65,000. So let's say there's a vehicle that your husband left to somebody else. As the surviving spouse, you can take that vehicle even though he left it to somebody else because that's your the right as a surviving spouse. Okay? In
Okay,
addition to that, there's another right where you could stay in the mansion house, which is the home. In addition to that, the surviving spouse is entitled to the first $40,000 or $60,000, depending on if there are children, if you guys have children together, or if you don't have any children together. Surviving spouses have a lot of rights when it comes to probate and the probate administration. And so what we always tell our clients, my clients, is look, if you really want control, so if the husband or the wife truly wants control, let's put these assets in a trust. Because if you put these assets in a trust, there is no surviving spouse right that's going to trump what the trust says because the assets are in the trust and they're controlled by the terms of the trust.
Of the trust. Mhm.
Hopefully that answers your question, but maybe not.
It does and it doesn't, but that's okay because you did give me some nuggets in there. The reason I am focused on the car, because I
Mhm.
don't want the car,
Okay.
but the license needs to be renewed on the car.
Mm.
And my plan is to give the car to his son, but because it is in my husband's name, I'm going to have to go to DMV
Right.
and get that transferred ownership to me, and then I can give it to the son. Am I correct in
You are
that?
correct. Yep. It's going to just be a two-step process. Yep. It would have to go to you first and then give it to the son. Now, if there is a if the vehicle was not in his name, but it was in his trust, then whoever his trustee is could have you sign a disclaimer and the trustee could just give it to the son.
Okay. But it is in his name. It is
Right.
titled in his
Right.
name, but not in the name of the trust. But
Right. And is he
uh
still alive?
who?
Your
My
husband.
husband?
Uh-huh.
No, he just passed 6 months ago.
Okay.
Yeah.
Right. Yeah.
So
So
um
you're experiencing exactly what I was talking about that 9 month period. Things are still in limbo. Uh,
things are still in limbo.
mhm.
Um and yes, things are still in limbo. Uh, and it's complicated by the fact that we live in Florida, but we have property here in Ohio as
Wow.
so. So right now, the hiccup is that the house that is in Ohio um, was in the name of his trust, and then at your death, then everything is retitled in the name of the trust itself, if I'm
Right.
saying that correctly.
Hmm.
Um, and the house he had signed a quick claim deed to deed that house directly to me, but either it got lost in the mail or whatever. And so now that house is sort of stuck out there,
Hmm.
uh, that we're going to have to figure out what we do with that house. I know it sounds confusing. And to anyone who's probably listening, it sounds confusing.
Yeah. No,
But these are the little things
I
that can
understand.
catch you up. And my husband died within 3 days. I mean,
Wow.
he had pancreatic cancer. He was
Sorry to hear that.
diagnosed 1 minute and he died within 3 days. Um, and so all of a sudden we find out that the house that is titled in his name as trustee,
Mhm.
um, of which he has signed a quit claim deed, which had been um, notarized, etc., did not get sent to the attorney, or else it got lost in the mail because it was sent from Florida to Ohio. And then
Yes.
we find out that, oh, guess what? Um, um, that
House is still
house
in the
now,
trust. Yeah.
yes, that house is still in the trust. So now um, that's these are the things that catch you up, that catch you up because you think everything is in place, and then you find out that everything is in place.
Right.
That is not in place.
Well, if you want, you can schedule a complimentary needs assessment with my team, and they can go over kind of the ins and outs of probate, so that we can kind of help you navigate this if that's something you're interested in. Um, and that's one of the reasons why I consider going to probate failed estate planning. Because if you have a will and a trust, there's no reason you should be tied up in probate um, court at all. But it
Right.
sounds like it's complicated for
It
sure.
is. It is. Yeah. Yeah.
Well,
Uh,
great question. Great question.
I was just challenged as to how to word the question because I know what I'm trying to ask. Uh, and what it makes sense to me in terms of what I'm trying to ask, but when I'm trying to ask it of someone, I'm not sure that I'm asking the right question. So I sort of know, what it is I'm trying to ask. So that's a complication right now.
Right.
Yeah.
Okay. Well, like I said, if you want, you can use that link that I put in the chat to schedule a
Okay.
complimentary needs assessment with my team, and they will be able to kind of walk you through the process and kind of explain what we can do to help
Okay.
if there's anything. All right. Well,
Okay.
thank you.
All
Any
right.
other questions out there? No? Any? No? Going once? Going twice? Going three times? All right. Well, thank you guys for attending the night seminar.
Thank
Um,
you.
we always like to have these seminars so that we can make sure that people have access to information. I truly believe that information changes situations. And as I always say, remember, where there's a will, there's a way. Where there's no will, then there's probate. But the best plan is a trust plan. And guess what? I'm your trust man. I'll see you guys next time and have a great night.
All right. Thank you.
Bye now.